Supplementary cause list for pronouncement of judgment, item 25 and 26.
Impugn declaration set aside, appeal allowed.
Deeply obliged.
Adjournment request, if any, from item number 1 to 8. From item number 9 to 18.
May I please, Lordship? Lordship, I'd like to mention item number 7 and 8. With the consent of the other party, I brief for adjournment for this matter.
7 and 8.
Yes, Lordship.
Why?
Lordship, my senior is very unwell right now.
Yes.
Lordship, with regard to item number 18 to 21, I pray for some condition, Lordship. Let the matter be fixed on 24th of January, Lordship. Outside councils are coming, Lordship.
24 January.
No.
The request of the brother. You have for the
Respondents.
respond.
Lordship, I have one more prayer in item number 23.
Yeah.
Lordship will not willing to take up the matter, the BPCL matter.
EPC, yes, another bench.
Obliged.
May I please, your Lordship.
Mention another bench 23.
May I please, your Lordship. My lord, I beg to mention item number 14 and 15.
Number,
Item number 14 and 15
yeah,
for the adjournment for this week, my lord. And the concern of the other side is, my lord, I have obtained, my lord.
then
Highly obliged, your Lordship.
May it please your Lordship? Lordship, I beg to mention item number 13, Lordship.
item number,
My lord, 13, Lordship.
Yeah.
My lord may not like to take up this matter since Honorable Mr. K. Goswami had appeared in one of the OAs, Lordship, which the petitioner had filed.
He's not here. Who is appearing?
Sorry, Lordship. Pardon.
Maybe
one of the OA,
Lordship, Honorable Mr. Justice Kaushik Goswami had appeared, Lordship.
that is in relation to this controversy only.
Lordship,
Another bench. Circle like that.
No. I'd like to mention for listing of IA Civil 3123, public 24, Your Honor, which has been, notice has been served to all the respondents. It's an urgent matter, Your Honor, because the respondent number 1 to 4 has already initiated for fresh interview in regarding Anganwadi workers.
Interview for what? For?
Anganwadi workers. Anganwadi workers.
Anganwadi worker.
Yes, Your Honor. Maybe in this week, Your Honor, the interview will be done. And if it is done,
So which date you would like to have?
day after tomorrow, Your Honor.
Day after
It's
tomorrow.
urgent, Your Honor, because if the
Okay.
blessed.
Any other request? Daily list for admission item 1. Item 1 to 3.
With your lordship. Lord, in the readable 215, my lord, by order it is 77/2024, your lordship desired to know, my lord. The Mr. A. Sharma, learned counsel, appearing for the appellant, prays for some time to satisfy this court that at the time of taking over Hindustan Fertilizer Corporation Limited by the appellant Brahmaputra Valley Fertilizer Corporation, the liability of the school run by the HFCL was not fastened upon the appellant corporation. That was the instruction sought, my lord. Mr. Sharma is not there, but then, my lord, I have some verbal instructions. Because Mr. Sharma was to take the instructions, my lord,
Mr. Sharma,
was to take instruction. In his case, my lord, that's
after hearing on merits,
my lord.
we raise this query, you just satisfy us, then we'll proceed further, sir.
Yes.
You have to satisfy the court.
Mr. Sharma, if you go.
Lordship, Mr. Sharma, he is appearing to the item number 2, Lordship. Due to some medical emergency, telephone, he informed me that he could not come, Lordship.
Or maybe either Mr. Chaudhary, you satisfy us.
Yes, my
or
lord,
Mr. Sharma may satisfy us.
I don't
then.
have any written instruction, but that, my lord, from a document and the oral instruction is there, my lord, it appears, my lord, this is the instruction, actually. It has been recorded in the, my lord, appellate order that the officers and workers of Namrup unit on roll as on 31/3/2002 have been transferred to BVFCL.
But either you just satisfy us that this liability of the school was not fastened upon you, certainly you have a case. Otherwise, if the whole, whatever this structure of the Brahmaputra, this, what is this Brahmaputra Valley Fertilizer Corporation is transferred to you, or is given to you, then certainly you are supposed to take care of all those.
Yes, your worship is right, my lord, but this instruction is one that I have been verbally informed, my lord, that is not very clear because they also say,
Okay, then get it, get a. clear
I'd like to
instruction.
have a written instruction on this, my lord,
Yes.
because they say, my lord, it is
So when?
a week, my lord.
Can it be taken on next Monday?
Monday I have got difficulty. Let me
Tuesday, Tuesday,
Tuesday is the hearing day, sir.
Wednesday, my lord. Oh,
today is also Monday, Tuesday, I think.
Yeah, that's why only. I'm.
Because your lordship, we
mentioning it.
finally hearing
Hearing
it.
day, it's difficult.
In 7 months, my lord, it's very surprising. We have got the instruction, full instruction in writing and also the judgment of the IFR. They couldn't get it.
Hey, we are not passing any order on this. Nikhil and the council, Mr. Chaudhary, place some more time to satisfy this court about the query raised on 17/7/2024. Based on you decide amongst yourself which day.
10th or 11th, huh? 10th or 11th?
Oh, 11.
11th. Oblige.
Item 4.
Right, please, your lordship. Lord, impugn order. It has page 93, madam.
Yes.
Page 93, 94, my lord.
Yes,
My lord, observation at page 95.
yes.
I have heard the learned counsel for both parties and given my anxious consideration to the above of the matter. In the opinion of the court, the question of relegating the petitioner now to again submit a representation would be a useless formality, taking into account that the petitioner was issued notice as on 31/7/2024, and the petitioner was duly heard before issuance of the impugned notice dated 19/8/2024. It is further seen that the land in question is a pond. Under such circumstances, the question of granting settlement to the petitioner over said land does not arise. In addition to that, the petitioner's application for settlement has also been cancelled. Under such circumstances, this court finds no ground to interfere with the impugned notice dated 19/8/2024. The respondents would be at liberty to take due action in accordance with law. Now, your lordship, again I am looking, taking into account the petitioner was issued, same paragraph, my lord, taking into account that the petitioner was issued notice as on 31/7/2024. So, my lord, my humble submission before your lordship,
31/7/2024 notice issued against that person. 31/2 notice, I am referring, my lord.
This point you have never raised before the learned people judge.
My lord, your lordship would be pleased to see.
This was not the point.
Page 58, my lord. Page 58, that was on record, my lord.
Whatever it may be, have you argued before the learned single judge that it was against the dead person?
My lord, that notice was on record, my lord, in the writ
Whatever it
petition.
may be, how this,
No,
without
no,
arguing
no,
that.
Your lordship would be pleased to see everything on record, my lord, is to be considered at the time of passing the impugned order.
Even though if it is on record.
My lord, your
from
lordship
where
would be
the
pleased to
learned
see
single
page
judge
58.
Able to know that this was against a
On
dead person.
that
until
aspect,
and
on
unless
that
you point it
aspect, my
out.
lord, on that aspect, learned single judge did not whisper anything.
Mr.
Just it is
When
said.
you argue,
My lord, your lordship would be pleased to see, that is on record, my lord, that is on record, page 58. Page 58. My lord, argue is another thing, my lord, that is on record.
that is
On the
absolutely.
basis, my lord, my humble submission before,
The judges are
on the
not bound
basis
and
of
they know
document.
each and everything that this notice is against the dead person.
No, my lord,
Until and unless
my
it is pointed
learned
out.
single judge, my lord, learned single judge has taken into consideration only the affidavit in opposition. Other documents not taken into consideration at all. Your lordship would be pleased to see the order. Impugned order, your lordship will look into. What has been considered, my lord? Just eviction notice, my lord. And it is held that 19/7, that 31/7/2024 notice was issued to us. That observation is there. Is it a proper observation, my lord? It is perversion record. Your lordship will turn to page 58. That is looked into by the single judge. That notice was issued 31/7/2024. Notice was issued to some persons, my lord, who are not related with the land. And among the 5 persons to whom the land was allotted, my lord, in 2010, out of that, only 1 person has been noticed. So no notice was given to us. 31/7, my lord, page 58, your lordship will look into. Number 1, my lord, Os Mahmud, that Soti Mahmud Sheikh, Jyoti Mahmud Sheikh, my lord, Ati Mahmud Sheikh, all are sons of so and so. Hajira Khatun, these 1 to 4 persons are dead persons, my lord. How notice can go against them? And who will represent them? My lord, my humble submission before your lordship that,
Where in the petition have you said that 1 to 4 is dead?
my lord,
Where in the petition have you stated that serial number 1 to 4 is dead?
in the writ petition, my lord.
Yes.
No, my lord, your lordship would be pleased to see in my writ appeal I have stated.
So what do you
But-
mean by writ appeal?
No, my lord.
Until and unless
My
you
lord,
point out.
that all right, my
You
lord, in
plead
the,
before the learned single judge, you argue before the learned single judge
my lord,
that this notice was to a dead
my
person.
lord,
How the learned single judge could know?
my lord,
You
your
have not
lordship.
even pleaded.
No, lord, when the learned single judge, my lord, when the honorable learned single judge held that notice was issued on 31/7/2024, that is the observation. Notice is not issued. That is perversion record, my lord. My humble submission before your lordship. Your lordship will consider this notice. And learned single judge consider this notice. This is not a notice at all. No hearing is done, my lord. Honorable single judge clearly said the notice was issued to us. Where is the notice, my lord? Para 6, it is clearly said. Petitioner was issued notice on 31/7/2024. Where is the petitioners, my lord? Petitioner was not served with any notice. It's an illegal order, my lord. And perverse on record.
So you were not heard.
I was not heard, first thing, my lord. And
Okay.
your lordship, second point before your lordship,
Just a minute. You were not heard.
I was
Now
not heard.
come to paragraph number 13 of the writ petition.
Paragraph
13
13
of
of
your
the
writ petition.
1 minute, my lord.
Page 33.
Yes, my lord, I have.
Read.
The petitioner begs to submit that the impugned order dated 19/8/24 is not at all sustainable in view of the facts and law, as because the issues raised by the petitioner in the hearing dated 31/7/2020 had not been considered at all.
So you were not heard.
No, my lord,
You were not heard.
I am before your lordship Amir Hussain. Whereas Amir Hussain is heard,
That you just tell me who is this petitioner?
my lord.
Who was this petitioner?
Amir Hussain,
Amir Hussain.
my lord,
And this paragraph number 13 relates to whom?
my lord.
This is.
Amir Hussain, no doubt, my lord. But
Amir Hussain.
here
The
your lordship.
petitioner, who is the petitioner? Amir Hussain begs to submit that the impugned order not at all saying via the fact that law, because the issue raised by the petitioner in the hearing dated 31/7/2000 not has been considered at all. So, Mr. Consul, sorry to say,
No, my lord,
you yourself are saying in the petition that I have raised some
Well,
issue that that are not been
that is
considered,
there,
and
my
now
lord,
you are
but
saying you have
I,
not been heard.
how I will be heard, my lord? That is a statement. That is a statement, my lord. That is a statement, but notice was not given to me. How I will be heard?
Why?
How I will be present, my
Even
lord?
though Notice was not issued to you.
My
Notice
lord.
was in the name of dead persons,
My lord.
including your deceased father,
My lord.
and you appeared and submitted your grounds.
No, my
It
lord.
appears that.
How I will
your
appear, my lord?
senior
I was
granted
not
to
given
you.
notice. My humble
So
submission.
this paragraph
No,
number 13, you.
my
this
lord,
is an incorrect
I was not
statement.
given notice, my lord. I was not given notice.
Sir,
How I will
this-
be heard?
I'm sorry, sir. Paragraph number 13 is an incorrect statement.
Yes, my lord.
It's an correct statement.
My lord, that I am to admit.
You have just.
That I am to
If
admit
it
that
is an
that
incorrect
statement is there.
If it is the incorrect statement on oath, then one more reason to dismiss this petition.
My lord.
How can you make an incorrect statement on oath before the court?
My lord.
And you have audacity to say this?
My lord.
It's too bizarre, sir.
No, my lord.
Amir
Your
Hussain, third
lordship, I humbly submit.
Read petition or read appellate.
My lord, I humbly submit before your lordship. Your lordship,
Page
both the
Page?
60.
my lord, your
60,
lordship,
my lord.
your lordship is to consider both the thing. One is the statement, para 13. One is the statement, para 13.
Sir, it's a statement on oath
My lord, that is there.
and with the assertion that
Let-
whatever I have said is
Let,
true
let
and
me, let,
facts I have mentioned. in
I
the
may be
petition
allowed
are
to
true
clarify
and
my
correct.
position, my lord. I may be allowed to clarify my position. I am before the writ court, my lord, writ appeal, my lord. I am before your lordship in appellate court, my lord.
In fact, my lord, the annexer G is under silence. And it's a notice, my lord, and a read petition and name.
May I submit, my lord?
Yes.
One thing, my lord, I am before the Honorable Division Bench, my lord. The statement under para 13 of my writ petition is before your lordship for consideration. Another thing is this, my lord, that notice I already pointed out to your lordship.
Pointed out before the learned single judge, sir, we are in the judicial review of an order of learned single judge.
My lord,
It's not an.
I
petition.
will try to reply that also, my lord. Your
Yes,
lordship would be
reply
pleased to
first.
see. Yes, my
Like
lord.
first,
First
where
one
you
is
have mentioned.
para 13, para 13.
Where you have mentioned in the writ petition that the notice impugned was issued to the dead persons, and where you have argued before the learned single judge, forget about arguing. Where is this contention in the writ petitions?
My lord. To that, my lord, my answer will be
Yes,
that para 13 is before your lordship and that notice is before your lordship. We are before the division bench and your lordship, what your lordship pointed out to me.
sorry to say, sir.
No, my lord,
Okay.
let me clarify, my lord. Let me clarify,
I'd like to clarify.
Have you please sit down?
my lord.
Sit down.
Both the statements is here and what your lordship pointed out, whether I have argued before the learned single judge this point, that I was not heard. Now your lordship,
No. Not heard is altogether different thing.
my lord,
You can't argue before the learned single judge against your pleadings. Because in para number 13, you have specifically said, I was heard, I have raised some issues and those issues were not taken into consideration. The question is where you have pointed out before the learned single judge that notice is nullity since it was issued to against a dead person. Where is that? Now you are trying to raise this issue. Where is that?
my lord, to that, my lord, that will be my repetition. That para 13 is before your lordship and the observation of the learned single judge is before your lordship and also the notice.
So you
So,
have
my lord-
admitted that you appeared before the authority concerned and you raised some issues. Yes, your contention is that those submissions were not taken into consideration and right perspective. This is what your case is.
My lord.
And the learned single judge has recorded a finding, no, he was heard
No, my lord,
and
what will happen to this finding that I was noticed?
which finding?
My lord,
This you
finding-
yourself have admitted, sir, in
Hello.
your pleadings.
my lord, that is not the observation of the learned single judge, my lord,
Okay, fine.
that I was heard.
Okay, fine.
That thing is this, my lord, learned single judge said that notice was given to me. That is not, that is on point, my lord. Now your lordship will come to another point. Your lordship would be pleased to say page 43, my lord, page 43. Here in page 43, my lord, in 2010, the land is allotted to me. Land is allotted to me, my lord, 2 Katha 11 Lessa by the subdivisional level advisory board. And thereafter, what happened, my lord? In administrative side, my lord, all process was progressing one after another. my lord. Your lordship will turn to page 52. Thereafter, what happened, my lord? Assistant Settlement Officer Sapor, a letter issued by the subdivisional officer, enclosing herewith the copy of settlement proposal, Hazrat Ali, Amir Hussain, etc. You are requested to submit the valuation of said land with the settlement proposal in original. It was of 2010, your lordship would be pleased to notice. In 2007, we filed application that land allotted to be settled with us. Now your lordship will turn to page 55. Assistant Settlement Officer support Revenue Circle from the subdivisional officer. With reference to the subject cited, I am to inform you that it is required filling up the checklist of filling up the proposal for allotment. It is continuing in 2017. Now your lordship will turn to page 56. To circle officer. It enclosing here with copy of prayer petition 2024 submitted by Amir Hussain regarding allotment and settlement of land so and so my lord. Now your lordship, another letter, my lord, page 57 from, my lord, it is the type photocopy. Now, my lord, your lordship in 19, in 2024, every actions regarding settlement of the land is taken. And thereafter, my lord, in 31/7/2024, abruptly, my lord, this notice has been issued that you are not entitled to the land. Now your lordship, how this has happened? There is a reason, my lord. In 15/7/2024, my lord, page 84. Some people of the local area, my lord, in 2024, after 14 years. 15/7/2024, some people of the local area filed a petition before the Chief Minister Assam. So Chief Minister Assam, after receiving this application, the office of the Chief Minister, my lord, the principal private secretary to the Chief Minister of Assam, issued a letter, my lord. Your lordship would be pleased to see page 87.
Yes,
In 2024, only new development, my lord,
yes,
on the basis of an application.
yes.
The applicants has no locate standi to do, but they approach the Chief Minister. And Chief Minister office issued this letter, my lord, page 87. From Principal Secretary to Chief Minister Assam. So Honorable Chief Minister placed the letter to the Principal Secretary and Principal Secretary issued this letter to the District Commissioner, my lord. And the District Commissioner, what happened, my lord? District Commissioner initiated the proceedings in 2024.
Yes.
Immediately, my lord, in 2024, every actions, my lord, for about 14 years, settlement was not done. In 2014, my lord, they approached the Chief Minister and immediately, my lord, within 3-4 months, my lord, our allotment is cancelled. Without any, another point your lordship will consider that by this page 88, my lord, I am referring. Page 89. Here what happened, my lord? The cancellation of allotment approved. Only cancellation of allotment approved. But as on today, my lord, they did not place this cancellation order. They did not give me the cancellation order, how the cancellation was done. What is the reason behind, my lord? That is not disclosed.
Mr.
Just
Counsel,
it is said,
What you are arguing,
My
whether
lord.
you pleaded in the petition or not, all these things which you have argued from
My lord.
us, sometimes.
my lord.
Have you pleaded all these things in the petition?
In the writ petition, my lord, that has been pleaded that actually that land was allotted to us. That is,
That's
what I am,
what you are
what,
trying to.
why am, what,
Convey before
my
that.
lord, what,
Within 4 months, the chief minister, office has instructed, where is that, sir?
my lord.
Where is all these?
No, no,
documents?
these
Where
are,
is
these
that?
are the documents annexed with this writ petition, my lord.
Sir, writ petition.
All
again-
documents were
again,
annexed.
you have to
What I
argue,
have
sir.
referred, my lord,
You
all,
have to plead,
my lord,
you have to plead all these things.
my lord.
Otherwise, how we take into
My lord,
consideration all these
my
arguments?
humble submission before your lordship, what is on record? What is on record,
Sir,
my lord?
ultimately,
It
again,
is,
we
it
want
is
to
not,
clarify,
it is,
we are
my lord,
not gods. What is there on the record? We are not supposed to go into deep into the record and find out that what is the record says. What you say, what you argue, what you plead, we have to decide the case as per same.
my lord,
On the basis of that, sir,
my humble submission before your lordship, I am trying to place before your lordship that what was on record. Your lordship in 2020, in 2010, my lord, an allotment has been made. And abruptly after 14 days, everything has been done. After 14 years, that abruptly cancelled without giving the cancellation order also. That is to be looked into, my lord. That all were on record.
So
that all were on record.
what
how
you
the
are
people-
insisting to look into the facts which have not been pleaded in the petition.
My lord, everything has been pleaded, my lord.
Where is that?
My lord, your lordship, documents I have placed before your lordship, annexure 1 to onwards. That is the allotment order, my lord. Everything is annexed with the writ petition, my lord.
Yes.
Your lordship, just I am going to the writ petition. Writ petition starts from page 26, my lord.
Yes.
Petitioner is preferred against the impugn eviction notice dated 19/8/2000 issued by the circle officer Sapor. Circle petitioner herein is one of the possession of the land in question and is a member of the joint family against which the impugn order of eviction has been issued. All named persons mentioned in the impugn eviction order are members of the same family and sons and daughters of so-and-so. The petitioner begs to state that he is the owner and possessor of a plot of land measuring 2 kata 11 lasas covered by the number so-and-so. The said land are in possession of the predecessors of the petitioner and are continuously in possession of the petitioner years together. It is pertinent to mention herein that the settlement proposal of aforesaid khas land of the petitioner has been approved by the subdivisional level advisory committee SLDC in its meeting held on 24/12/2010 in favor of the petitioner subject to deposit of the due premium to be fixed by the government. The said proposal for circular's allotment of the land has been done as per gov policy and the concerned land reforms acts and laws. That the petitioner begs to state that pursuant to the aforesaid SLDC meeting, the IC subdivisional officer Bilasipara, by letter dated 19/8/2021, had requested the assistant settlement officer Sapor Revenue Circle to submit the valuation of the land of the petitioner along with settlement proposal in original.
We'll read this.
Madam.
No need to.
Madam. So,
Read.
no, my lord, my humble submission before your lordship, everything on record. My settlement proposal in 2010, that is on record. Official communications that do the needful for settlement, everything is on record. So, my lord, after only affidavit in opposition has been filed, in the affidavit in opposition, they filed some documents, my lord. Your lordship would be pleased to see. On the basis of that document, my lord, the learned single just passed this order. This is, my lord, this is most arbitrary order, my lord. Because, my lord, your lordship will consider everything. How in 2024, everything has happened. Only because of pressure from dispute. Immediately letter has come and immediately everything is. And your lordship would be pleased to see, as on today, the cancellation order is not placed. Cancellation order by the respondent did not place before your lordship.
That's all, sir.
Yes, my lord.
This writ of appeal is proposed by the petitioner challenging the order dated 15/9/2024 passed by the learned single judge in writ petition number 4421/2024. The appellant has approached the rest court challenging the notice dated 19/8/2024, whereby the petitioner was directed to vacate the said land within 3 days from the date of receipt of the said letter. Stop. Initially, writ court has granted interim order in favor of the appellant. However, the state respondents has appeared before the single judge, has entered their appearance and however, the state government, later on, the state government, the council for the state government has entered appearance on behalf of the state government and stated that the land in question cannot be settled in favor of the appellant as the same is a pond in bracket water body, full stop. Considering the rival strengths of the parties, the learned single judge has dismissed the writ petition, disposed of the writ petition filed on behalf of filed by the petitioner while observing as under para number 6, 7, and 8. Learned counsel for the appellant has submitted that the learned single judge has not taken into consideration the fact that the impugned notice dated 19/7/2024 was issued against dead persons and the name of the petitioner and no notice was issued to the petitioner 31/7/2024 and the impugned notice. And no notice was issued to the petitioner present his case. Full stop. We have gone through the pleadings and find that there is no averment in the writ petition to the effect that the impugned notice dated 31/7/2024 was issued against the dead persons. Apart from that, the contention of the learned counsel for the appellant that no opportunity of hearing was granted to the petitioner is also contrary to the averments made in the writ petition. In para number 13 of the writ petition, it is specifically stated by the petitioner, by the appellant, that the issues raised by the petitioner in hearing dated 31/7/2024 in response to the notice specifically stated that in response to the notice dated 31/7/2024, the appellant has raised issues, certain issues before the respondents, but the respondents has not considered those issues at all. Full stop. Learned counsel for the appellant, in view of the fact, in view of the above fact, it is clear that the contention of the counsel for the appellant that the appellant was not provided any opportunity of hearing before passing the impugned order is incorrect, and the same cannot be accepted. Full stop. Learned counsel for the appellant has tried to argue, has tried to raise certain points. However, the same points have not specifically been pleaded in the writ petition nor argued before the learned single judge. The attempt on the part of the appellant to justify his actions contrary to the pleadings to the writ petition on oath is not appreciable. However, we restrain ourselves from not appreciable, and the writ appeal is liable to be dismissed with heavy cost. However, we restrain ourselves from imposing any cost as the in the facts, imposing any cost in the facts and circumstances of the case. The writ appeal is therefore dismissed.
My lord, I may be excused, my lord. Only one point, my lord. My lord, your lordship did not impose cost on me, and that I am grateful to your lordship.
Yes.
Another point, my lord, only one point, that this cancellation order, as on today, that was my point, my lord,
That
is not given.
Item 5.
My lord, to be honest, I'm not fully prepared today. Can I pray for little accommodation? Your lord?
May I pray for a date, madam? It's some urgency, madam. There is
Is there any stay?
there is an interim order making the appointment subject to the outcome of the writ petition. So we are unable to make,
Such order.
my lord, we are unable to make the subsequent promotion, my lord. They are due. Those who have been appointed.
My lord, firstly, any date convenient to lodge, your lord?
28 January, 28.
তাহলে যাবো।
Item 6 for hearing.
Who is appearing for the state? In the last occasion, some statement was made that government is considering to raise their honorarium or remuneration or one of the occasion it was the stand of the something for the respondent.
My lord, till now, that has not been done. My lord.
This on 21/3/2024, some statement was made that this matter regarding hike in the remuneration and something is under consideration with the state government.
My lord, in the affidavit filed by the government, my lord, there is a my notes of a meeting dated 8/6/2022, which says that they have raised it to ₹100 per day instead of 86 rupees. 14 rupees has been hiked. My lord.
You know, think I remember, but this was.
Yes, my lord. I
three
also
times
remember.
they have
Yes,
appeared and
yes.
They said, we are thinking of increasing that remuneration and something.
My lord, give them some time so that they can take the up-to-date instructions.
Actually appearing in the, on behalf of the state. When it's 100 rupees, it's too low. At least, and I think some impression was given to us that you are, this is under consideration for raising some, this. What about that?
It's nothing, nothing in writing.
Whether it is under consideration or not, or we have to pass some orders. Yeah. Then it concept appearing for the state. Submitted that. She has no instructions whether the issue regarding enhancement of honorarium to the VPOs.
VDP.
Huh? VDP.
BDP, my lord.
VDP is under consideration with the state government or not. Stop. She plays some time to complete an instruction on this aspect. This matter when fourth of February.
I'm obliged.
Item 9.
Madam. Hello, before going to my, can you have a look at that order dated 22/4/2024?
22nd of April.
22nd of April.
Yes. Yes, Mr. Who is appearing for the finance department? P9.
Yes, my lord. P9 was probably on late in another court.
Pass over for the time being.
Yes.
Item 10 to 12.
Lordship, I am praying for an accommodation for today, your lordship. I am appearing in item number 10, your lordship. Lordship, in item number 11, your lordship. Praying for accommodation for today, your lordship. Yeah. Not your best.
Item 16.
Yes, my lord, I appear for the respondent number 1 writ petitioner, my lord. On the last occasion, my lord, I had raised the point on the maintainability of the writ appeal, my lord. Before my lord goes into the merits of the matter, my lord, I would like to only beg to submit, my lord. This is a appeal filed by the government from a judgment and order dated 28/3/19, passed in a writ petition criminal, my lord, praying for habeas corpus, my lord. Now, my lords, my lords are aware, my lords, latest patent is not applicable to the Guwahati High Court, but intra-court appeals are governed by the High Court rules, my lord, framed under Article 225 of the Constitution of India. If my lord kindly takes up the High Court rules for a moment, my lord. Chapter 5A, my lord. My lord kindly takes up chapter 5A. Of the 5A of the High Court rules, my lord. Page 5A, my lords. If it's the same book, my lords, it should be at page 55, my lord. The judgment of the High Court of Petition. Deva Prasad Dr. Kinikon copy.
Yes.
Yes, my lord, may kindly see the heading, my lord, of chapter 5A. Chapter 5A governs intra-court writ appeals, my lord. Chapter 5A reads, my lord, rules governing application for directions, order or writs other than in the nature of habeas corpus under Article 226 of the Constitution of India. Thereafter, my lord, may kindly peruse sub-rule 2, my lords.
Yes.
An appeal of the judgment and order of a single judge disposing an application shall lie to the division bench. If preferred within 30 days of date of such judgment, the division bench may condone the delay in filing any appeal if good and sufficient cause is shown. Now, this would apply only in cases, my lords, where...
In that way, if we go by this argument,
Yes, ma'am.
then how this learned single judge has derived the jurisdiction
Yes.
to decide this habeas corpus petition? Because the habeas corpus petition have to be decided by the division bench.
No, my lords, because at that point of time, my lords, maybe there was a notification for matters to be listed before the division, before the single bench, my lord.
No.
It is at the discretion of the Honorable Chief Justice to constitute benches, my lord, to take up
Sir,
the.
provided that such application falling with any of the one or more of the following categories shall be heard by the division bench except where the chief justice otherwise directs.
Yes,
Public interest litigation and base corpus petition.
yes, my lord.
Must to be heard by the division bench.
No, at that point of time, my lord, it was,
Where is that notification? You just show us.
well, it was listed before the single bench, my lord. It was an application. under-
Mahanta, so was the notification?
My lord,
The notification that the Leonard single judge has the jurisdiction.
I was not anticipating that, my lord. I'll come with the notification.
Once you are raising this is intra-court appeal is not
In fact,
maintainable, then
that
this is
has-
the core question.
That has also been decided by Honorable Chief Justice Mehta, my lord. The same thing has arisen before him, my lord. This is the judgment, my lord.
What have they
The
decided?
criminal matters cannot be taken up in writ appeal, my lord. So my lord, can
Sir,
we?
writ appeal is altogether different, sir. Here, the learned single judge, you are saying that it's a habeas corpus petition and therefore
Yes.
intra-court appeal is not maintainable.
Yes, sir.
First of all, satisfy us how the habeas corpus, this petition would lie before the single judge.
My
Because
lord,
rule specifically says
my lord.
that it is to be heard by the division bench.
Well, if I may kindly,
Unless the chief justice direct otherwise, where is that direction of the chief justice?
it's a matter pertaining to the year 2019, my lord. I'll take instructions on that.
17.
The the writ petition is registered in the year 2017, my lord.
17.
Judgment is
So
made.
show us the notification that there was a direction from the chief justice that is to be heard by the single bench. Certainly you have a point.
Give me some time, my lord. I'll check out from the.
If we rely on this argument, then we have to record a finding that
Yes.
the learned single judge has no jurisdiction.
I'll check from the registry, my lord. I'll check from the registry. Otherwise, it could not have been listed before the single bench, my lord. Because it was habeas corpus, it was registered as WPC
Yes,
criminal.
ready.
I'll find out, my lord. I'll find out and I'll appraise, my lord.
Prepare for that if you are raising this point.
They have enjoyed the fruits of the order passed by the learned single judge. And complaining non-compliance of that order, they have also instituted a my lord contempt proceeding. Now, in the meantime, this writ appeal came to be filed. Delay was condoled, and under the scheme, my lord, rupees 3 lakhs, which is,
That.
No, I am not on merit, but
You should also prepare, Mr. on this point regarding the maintainability. Come with the specific case. Have you raised this point during the appeal that the learned single judge has no jurisdiction to decide this habeas corpus petition?
Never, my lord. So not raised, my lord.
precisely not.
People are,
No, that argument is coming from that side, and that is without any pleading, my lord.
this is if the learned single judge has no jurisdiction, this should be a main point. That this order is without jurisdiction. Without looking at it.
In fact, my lord, Honorable Justice Mehta had held, my lord, in the judgment. Which my lord, I'll just read out the paragraph, my lord. Having heard the discussion made herein above, we are of the firm view that intra-court appeal does not lie against an order judgment passed by the learned
This is
single
the
bench
law.
in exercise of human rights. In fact, the register was directed, my lord, not to.
Where is that?
I'll find out, my lord. I'll find out. I'll place it.
We can't ignore the rule.
My lord.
Yes.
And
That's it.
item 17.
I'm on a sticky wicket, Lordship here.
Very sticky.
Very sticky wicket. So I have decided that to abandon the game and let another game be played later on. So regarding that issue of whether individual is allowed or not, that is a mistake on our part. We are going to rectify it. So that will not be an issue. And the other point is that there is no mechanism to say what type of trade and etc.
Must be some material.
Yes, there is no mechanism. We accept that also.
Very well.
Yes, so we leave this to the,
Decide an application.
yes. So we'll decide as per the existing one, that if he mentions trade, we'll have to give it because we have no mechanism to control what type of trade he will do, or we have no jurisdiction also. So that Lordship will read it down. So these are the 2 points. Otherwise, Lordship, the act is valid.
No, yes, otherwise it is valid. There are certain other points. You go through the rules, the respective amendments in view of the amendments made in the principal act has not been incorporated in the.
Yes, Lordship, there are lots of gray areas. It was very, very hurriedly done amendment, Lordship.
So why don't you come with the amendment?
We are going to do it, Lordship.
So you do it and then will dispose of petition in that manner, sir.
Lordship, after our amendment, Lordship,
Yes.
then Lordship will give us a,
Reading down is somewhat, it's a matter which
yes,
needs some consideration. But if the state government principally agrees
yes,
to get it.
we agree, Lordship.
Then you do it.
Then Lordship will kindly give us 3 months' time. The matter may come up.
It's a long time.
At least 2 months' time, Lordship. We'll do it.
My lord, with great
We, in fact,
respect,
will try to do it in this winter session itself. 2 months will be reasonable, Lordship.
with great respect, my lord, I really appreciate the fair submission on behalf of the AG. Now, the amendment will take some time. If we see the provision, my lord, it requires a prior sanction from the President of India also. I accept the urgency expressed by the learned AG. Now, therefore, without going into the matter,
Your problem will be solved.
loud, without any-
One hour. Okay. Meeting will be cycle. As per existing. You give a place certification and as per existing without any.
Mr. Sikya,
Lordship,
you come with this amendment in the meantime,
Lordship.
any application moved by him.
Yes, Lordship. Yes,
Consider
let him have file.
So own merit and then.
As per the existing law. As per the existing law, I mean, trade means we don't have any mechanism. So if he says
That
trade,
is- that
we
is-
have to give him.
you are Giving, after
Yes.
giving opportunity to him.
Yes.
And
Lordship,
considering all the matter, you can
Lordship.
pass a speaking order.
Lordship, we'll do that.
Okay. Mr. Sikya. And it's look at them, let's clearly consider that. The amendment to the subsection 4 of section 7 of the Assam Cattle Preservation Act 2021 law wide notification dated
Page 50, my lord.
wide
Act.
notification dated 28th of January 2022. This is the thing. No. 28th of January 2022. Restricts the jurisdiction of the competent authority to issue permit to issue permit only to the agency or farm registered under the Animal Husbandry and Veterinary Department, Assam. And in view of the said amendment, any individual cannot move an application seeking permit for transport of cattle for bona fide agriculture or animal husbandry purposes from the state of Assam. Mr. Sekya has submitted that the state government has principally agreed to make suitable amendment in the Act of 2021, unable to be unable to make enable any individual to apply for permit of transport of cattle for bona fide agriculture and animal husbandry purposes. Mr. Sekya has also submitted that there are certain other gray areas in the Act of 2021 and the rules made thereunder, and the state government is actively considering to remove the same. So Mr. Sekya has therefore has faced 2 months' time to do the needful. Stop. In view of the above submission, the limit appropriate to cut time to the state to do the required exercise. In the meantime, the petitioner is allowed to move application seeking permit for transportation of cattle from the state of Assam
Through the state of Assam.
through the state of Assam
Yes, yes.
for bona fide animal husbandry and for bona fide agriculture or animal husbandry purposes.
For the purpose of trade, my lord. for the purpose of
Yes.
rate.
For the bona fide or animal husbandry purposes or for transport, for trade
Yes.
For the sake.
within a period of,
But within 2 weeks, we will put up the application.
within a period of 2 weeks,
Right.
from, within a period of 2 weeks, if any such application is moved
Right.
by the petitioner, the respondents are directed to consider and decide the same
Yes.
by a speaking order after providing opportunity of hearing to, after providing opportunity of hearing to the petitioner, ignoring the restriction imposed by subsection 4 of section 7, wherein only an agency or farm registered under the Animal Husbandry and Veterinary Department can apply for issuing permit. The respondents shall take a decision on the application filed by the petitioner within a period of 2 weeks from the date of submission of such application.
What's it? Trade relating to animal husbandry and agriculture. What's it?
For trade, it's a difference, sir.
Different.
Trade is a-
Trade relating to the those two components.
Trade is,
Trade is a separate purpose.
It's a separate,
Madam, page number 64. Madam.
this bona fide agriculture for the this for transport of for bona fide agriculture purposes or animal husbandry purposes or for transport of
Cattle for trade.
transportation of cattle for trade.
Trade, trade for the said purposes it is written.
For the said purposes, let us see you.
Yes, sir, we'll give it, Lordship. That is not because
Opportunity of hearing,
Lordship.
pass a speaking order within a period of 2 weeks thereafter.
Lordship.
From the date of submission of application by the petition. Within 2 weeks from the date of submission of application. Does this matter? In the month of February.
February.
Highly obliged. Lordship.
Deeply obliged.
Pass over matter 9.
Instruction different. There. Lordship, this is the instruction I received. Very briefly. If Lordship comes to, pleases to come to page 33, Lordship. The read pitch. Yes, Lordship, page 33. Lordship, may kindly see the serial number 4, staff nurse. Lordship, 2 qualifications are there, Lordship. One is BSc nursing, BSc degree in nursing or
candidates who have PU examination and have undergone 3 years diploma in nursing and midwifery prescribed by the Indian Nursing Council. So this post is open for both BSc nursing as well as for diploma holders. Now, till 7 pay commission lordship, that is till 2017, same grade pay was allowed to both the categories. In 2017 lordship, this provision was given that those who are having graduate degree, they will get higher grade pay.
Where is that?
Just instruction law. That is the challenge here, Lord.
This, page 33, you referred to this, and now this one.
Yes, Lordship. Dear Lordship will kindly see in the second half, next, below the table below one, Lordship. Lordship may kindly see the third column. Pay band 2, 14,000 to 70,000, grade pay 6,800. And grade pay 8,700 having BSc nursing degree.
Where is that, 7th ABCC recommendations are?
Yes, Lord. 190. 190. Ekon kita nasa ni? 190. 2007. Ekon ay lolo. That purple flag. Lord. Stop now. Please. 193, 190. Health and family welfare. That is health and family welfare department. H below. H F D H D H H. Head further. Health and family are vertical. Partner and okay. Like it, my jump download.
What is the justification for? What is the justification?
Justification
To discriminate between these two persons, these two set of employees, until the 7th pay commission, the grade pay was similar. What is the
it
justification?
was on the basis of the higher educational quality.
Sir, higher education qualification, but what about the discharging the duties? And Health and Family Welfare Department has in fact supported their case.
No,
Yes,
no,
they are.
no. If Lordship comes to page 51 and 50 of the same repetition, Lordship.
51,
50. So, yeah, okay, Lordship may come to page 50. 53.
50,
51.
51.
Yes, this is an advertisement, Lordship, of 2020.
These advertisements made in the COVID period, Madam. Okay.
Next part. Yes.
Lordship may kindly see serial number 1, staff nurse. Now, Lordship may staff nurse, page 51. Staff nurse, post is name of the post, staff nurse. Lordship may kindly see qualification. This is only nursing, BSc nursing. Now, Lordship may kindly see the grade pay. So this is the same advertisement issued by the health department only.
Whatever, what is their affidavit? What is their affidavit?
No.
You mean to say that the staff nurse cannot be appointed with having this diploma in, the qualification of diploma?
So
They are
this,
not entitled for appointment.
why not this advertisement?
Advertisement, what about the rules?
Rule says both degree as well as diploma.
Then this, whatever it may be, if the advertisement is going to be challenged,
Lordship.
then it can't.
No, Lordship,
stay
basic issue will be
Of
whether on the basis of.
Sir, you have to justify on what ground, you know, differentiated between these two persons. You show us the ground.
The basic issue will be whether on the basis of higher educational qualification, there can be distinction in the pay scale or not.
Yes.
That is the basic issue, Lordship.
Yes.
But on that issue, Lordship, I would like to place 2-3 judgment, Lordship. But prior to that, if Lordship comes to the prayer, Lordship,
Prayer.
page 10. Page 10, Lordship.
Yes.
Issue rule calling upon it. Authority issued commanding the respondent authority to make necessary correction to the Assam Services Revision of Pay Rules 2017. So according to the petitioners, this is a mistake committed by the Pay Commission, Lordship. Now, if that provision is challenged, Lordship, either your Lordship will set aside that provision or Lordship will appeal that provision. Now, Lordship will definitely pass an order for correction of the rule, Lordship, because this is a 309 rule.
Whatever it may be, the sum and substance of the petition is that this validity of the rule is under challenge. What's the problem in that?
No.
That is the sum and substance. And do one thing. You file a amended this prayer, challenging the validity of this rule itself.
But even when
And
a
if
rule,
the discrimination is made, you made a specific challenge to that.
well, as far as the ROP 2017, madam, we are working, madam, without any push, madam. Without any push, madam. And can level is, madam, ROP staff nurse means, madam, according to
Without
ROP,
any post.
madam, according to ROP 17, madam,
Mr. Khanickar, clarify without any
push, madam.
Post.
Madam, because according to ROP 17, madam, staff nurse means only those who have BSc Dicky.
That's another thing. So that.
This is the only, madam, this mistake committed by the ROP.
In a way, I'm right in saying that you are not challenging the specific validity of this rule, which discriminate between the staff nurse and this BSc and the diploma holder.
Right.
Make a specific challenge to this. Do you understand
Right.
what we have said?
Right.
Make a specific challenge that this validity of this, declare it as ultra vires. Then we can only give, otherwise you are saying, direct them to make necessary correction. This court essentially has no jurisdiction to ask them to legislate a law in particular matter. This is what the law is. Challenge the validity, make this, that is discriminatory and all, then we'll consider it. Make a challenge. Because, Mr. Nair, apparently we don't find any reason to discriminate between these two persons. What is the discriminate about? How you can discriminate? When they are discharging the same duties, both the persons can be appointed as a staff nurse. Either you show something that there is a dissimilarity between the work or the responsibilities, then certainly you can make be able to make out a case of the difference between these two persons. Then only you can make out a case that for that purpose we have granted higher pay scale to the employer.
Appropriate restriction, I will definitely try to make those submissions. But definitely when Pay Commission recommended,
yes,
those justifications are definitely there. I'll amend it.
Amend 1 week.
Hello?
1 week.
Okay.
Here. By way of this petition, essentially, the petitioner has challenged the validity of the which specific provision is there? Validity of the rules of Assam Service ROP Rules 2017. Specifically, the provisions where the staff nurse having BSc nursing degree has been provided grade pay higher than the petitioners who are also working as staff nurse but are diploma holders. Would stop. Learned counsel for the petitioner raise a week's time to make specific challenge to the provision which provides higher pay scale, higher grade pay for the staff nurse having BSc BSc degree.
BSc nursing degree. BSc nursing degree.
BSc nursing degree and the BSc nursing degree, that's all. Just after a week, make a challenge and
Okay. Diplo.
Item 22.
What latest judgment?
Yes,
So
but it's
they-
already squarely covered, my lord. In fact, they have given a compilation of my lord, judgment. Page 31 is the judgment, man. This issue has been dealt with by the Honorable Supreme Court in P.A. Bhatt's case. That of Gujarat versus P.A. Bhatt.
Thereafter, I think so PA was, once was again sent for reconsideration.
No, that my lord, review was also dismissed.
This-
So this is the holding the field, my lord. This judgment is holding the field.
Your Lordship, my senior is engaged in a part-heard matter today, Your Lordship. Please be replaced.
Item 24.
Same prayer, Your Lordship. Deeply obliged.